October 24, 2016. A Monday morning. In a boardroom at Bombay House, the heritage building in Mumbai's Fort area that has served as the headquarters of the Tata Group since 1924. A building whose very walls carry the weight of 148 years of Indian industrial history, something was happening that had no precedent. The Tata Sons board of directors had assembled. The agenda circulated in advance made no mention of what was about to occur. And in a meeting that lasted minutes rather than the hours one might expect for a decision of this magnitude, the board voted to remove Cyrus Pallonji Mistry as executive chairman. A brief press statement was issued. Within hours, it was the lead story on every financial news channel in India. The most iconic industrial group in the country had fired its own chosen chairman, the first person from outside the Tata family ever to hold that role in the group's history without prior notice, without public explanation, and without any process that anyone outside that boardroom could examine or question. And India's corporate world, which had spent years watching Mistry work to reshape one of the nation's most complex conglomerates, found itself asking a question it had never previously had reason to ask about the Tata Group. What exactly happened in that room, and was it legal? To understand why this question had the answer it eventually did, you must first understand what the Tata Group actually is. Not in the way that a television advertisement describes it, but in the way that a company lawyer would. Tata Sons Private Limited is the principal holding company of the Tata Group. It owns controlling stakes in Tata Consultancy Services, the most valuable technology company in India. It owns Tata Motors, which manufactures Jaguar Land Rover vehicles sold across the world. It owns Tata Steel, which operates plants in India, the United Kingdom, and the Netherlands. It owns Indian Hotels, which runs the Taj chain. It owns Tata Chemicals, Tata Power, Tata Consumer Products, and dozens of other enterprises. The group as a whole employs over 700,000 people across more than 100 countries and generates revenues that place it among the largest conglomerates in Asia. It is not merely a company, it is an institution. And at the top of that institution sits Tata Sons, the holding company, which is itself owned in a specific and highly consequential way. The Tata Trusts, primarily the Sir Dorabji Tata Trust and the Sir Ratan Tata Trust, both registered as public charitable foundations, hold approximately 66% of Tata Sons. The Shapurji Pallonji Group, controlled by the Mistry family, holds approximately 18.5%, making them the single largest individual minority shareholder. This ownership structure is the foundation of everything that followed. Cyrus Pallonji Mistry was born in 1968, the son of Pallonji Mistry, the patriarch of the Shapurji Pallonji Group and one of the wealthiest individuals in India. The SP Group was itself a historic enterprise, a construction and engineering conglomerate that had built some of India's most recognizable structures, including significant portions of the very Bombay House building from which Cyrus Mistry would one day be removed. The Mistry family had been shareholders in Tata Sons for decades, and Cyrus had served on the Tata Sons board as a non-executive director since 2006. When Ratan Tata announced in 2011 that he would retire as chairman of Tata Sons the following year, the selection committee, tasked with identifying a successor, spent months in a structured, confidential process. In December 2012, Cyrus Pallonji Mistry was named the sixth chairman of Tata Sons and the first to hold that position from outside the Tata family since the group's founding. It was widely described as a historic appointment, a signal that the group had matured to the point where professional management could be fully separated from founding family control. It lasted 4 years and 18 days. The 4 years of Mistry's chairmanship were not uneventful. He had come in with a clear-eyed assessment of the group's strategic position and had identified, in his view, a number of significant financial and operational challenges that required urgent attention. Tata Teleservices had accumulated massive losses in the fiercely competitive Indian telecom market and was, in his assessment, unlikely to ever generate adequate returns. Tata Motors' European operations faced structural challenges that the acquisition of Jaguar Land Rover had not fully resolved. The Tata Nano, the much celebrated small car that had been a personal passion project of Ratan Tata, had never achieved the commercial scale its architects had envisioned. Mistry had raised concerns about these situations through internal channels, in-board presentations, and written communications that formed part of the institutional record of his tenure. He had also, in his telling, encountered resistance from board members who remained closely aligned with Ratan Tata, whose active presence and influence in the group had not diminished despite his formal retirement. Whether these concerns were raised appropriately, whether the resistance he encountered was commercially sound, these were the questions that would eventually arrive before a tribunal and ultimately a court. Within weeks of his removal, Mistry and his investment companies, Cyrus Investments Private Limited and Sterling Investments Corporation Private Limited, filed a petition before the National Company Law Tribunal, Mumbai bench. The NCLT is a specialized tribunal established under sections 408 to 434 of the Companies Act 2013, with exclusive jurisdiction over company law disputes in India, including insolvency proceedings under the Insolvency and Bankruptcy Code and matters of oppression and mismanagement under the Companies Act itself. The specific provisions invoked in Mistry's petition were sections 241 and 242 of the Companies Act 2013. And understanding these two sections is essential to understanding everything that followed. Section 241(1) allows any member of a company, any registered shareholder, to petition the tribunal on two broad grounds. First, that the affairs of the company are being conducted in a manner prejudicial to public interest or to the interests of the company itself. And second, that the affairs are being conducted in a manner oppressive to any member or members. Section 242 then gives the tribunal sweeping remedial powers once it is satisfied that such conduct exists. Power to regulate the company's affairs, to order the purchase of shares from one member by another, to appoint new directors, to order changes in management structure, and even, in extreme cases, to order the winding up of the company. Mistry's petition argued all of this, that his removal was an act of oppression against the minority shareholder, and that the management of Tata Sons had been conducted in a manner prejudicial to the company's interests across a range of specific business decisions. The Tata Group's defense was clear and legally straightforward. The removal of a chairman, the group argued, is a decision entirely within the board's constitutional authority. The Articles of Association of Tata Sons, the foundational document of a company, registered with the Registrar of Companies under Section 5 of the Companies Act, which sets out the rules by which the company governs itself, give the Tata Trusts certain enhanced governance rights that went beyond what their 66% shareholding alone would have provided. These rights had been part of the articles since before Cyrus Mistry became chairman. They had been accepted by the Shapurji Pallonji Group as a shareholder, and they were, the group argued, entirely legal. More fundamentally, the Tata Group argued that there had been no oppression of the minority shareholder in any legal sense. Mistry's family still held their 18.5% of Tata Sons. They still received the economic benefits of that holding. They still had their voting rights as shareholders. The removal of Cyrus Mistry from an executive management role, however sudden, however dramatic, was not the same thing as the suppression of the minority's rights as shareholders. The law, the group argued, draws a clear line between what a person owns as a shareholder and what a person occupies as a manager. Mistry's family had not lost their shares. Mistry had lost his job. These were different things. The NCLT heard the petition over several months, examining a large volume of documents, board minutes, internal communications, and financial analysis. In July 2018, the NCLT dismissed the petition in its entirety. The tribunal held that the standard for establishing oppression under Section 241 is a high one. The conduct must be shown to be burdensome, harsh, and wrongful, going beyond mere commercial disagreement or management difference of opinion. The removal of a chairman, even without prior notice, and even if the affected person considers it unjust, does not constitute oppression of the minority shareholder unless it can be demonstrated that the removal was designed to harm the minority's economic interests or to strip them of their legitimate rights as shareholders. The NCLT found that the evidence before it did not meet this standard. Mistry appealed to the National Company Law Appellate Tribunal, the NCLAT, which sits above the NCLT in the company law judicial hierarchy and hears appeals from NCLT orders under Section 410 of the Companies Act 2013. What happened at the NCLT was one of the most remarkable developments in the history of Indian corporate law. In December 2019, the NCLT delivered a judgment that overturned the NCLT order in almost every material respect. The Appellate Tribunal reinstated Cyrus Mistry as executive chairman of Tata Sons, an order that, had it been implemented, would have required the company to restore to the position it had removed him from 3 years earlier. The NCLAT declared the conversion of Tata Sons from a public company to a private company, which had been completed in 2017, illegal and void. It issued wide-ranging orders about the governance of Tata Sons going forward. And it characterized the conduct of Ratan Tata and the Tata Trusts as constituting oppression of the minority shareholder within the meaning of Section 241. The Indian corporate community reacted with something close to disbelief. A regulatory tribunal had ordered the reinstatement of a removed chief executive. No such order had ever been issued in the history of Indian company law. The implications for corporate governance across every listed and unlisted company in India were potentially enormous. The Tata Group filed an emergency application before the Supreme Court of India that same day. The Supreme Court granted a stay of the NCLAT order. Cyrus Mistry did not return to Bombay House. The conversion of Tata Sons from a public company to a private company, which the NCLAT had declared illegal, deserves its own careful explanation. Under the Companies Act 2013, a public company is one that, among other criteria, has more than 200 shareholders or is incorporated as a public company. A private company restricts the transfer of shares, limits its membership, and prohibits any invitation to the public to subscribe to its securities. The distinction matters because public and private companies operate under different regulatory regimes, with public companies subject to more stringent disclosure and governance requirements. The conversion of Tata Sons from public to private status changed the regulatory framework governing its shareholdings, including, most significantly for the Mistry family, the rules governing their ability to transfer or sell their 18.5% stake. The NCLAT held that this conversion was carried out specifically to prejudice the minority shareholder and was therefore illegal. The Supreme Court, as we will see, reached a different conclusion. Tell us in the comments where you are listening to this story from. If this story is making you think about how power works inside India's great institutions and who the law protects when things go wrong, please like, subscribe, and share this channel. Every subscriber tells us to keep bringing stories like this one. Now, back to the story. Writing hand, a note from our team. We have researched this case extensively to bring you accurate facts, dates, and legal details. However, these cases span years of complex proceedings, and some details may be imperfect. If you spot anything that needs correction, please leave it in the comments. Your input helps us serve every listener better. The Supreme Court of India heard the appeal against the NCLAT judgment over several months. The arguments were among the most sophisticated and consequential corporate law arguments ever placed before an Indian court. On March 26, 2021, Chief Justice S.A. Bobde delivered the Supreme Court's judgment. It was comprehensive, carefully reasoned, and unambiguous in its conclusions. The court overturned the NCLAT order in almost all material respects and restored the basic principle that those who bear the greatest economic risk should have the greatest say in how the enterprise is run. The court held that the removal of Cyrus Mistry, while sudden and without prior notice, was within the board's legitimate authority and did not constitute oppression of the minority shareholder. The court observed explicitly, in words that will be quoted in Indian company law classrooms for decades to come, "We have not found any merit in the argument that majority rule has taken a backseat by introduction of corporate governance in the Companies Act 2013. On the Articles of Association and the special rights given to the Tata Trusts, the court held that these rights were entirely legal. Shareholders are entitled, within the limits set by the Companies Act, to negotiate governance arrangements that reflect their specific circumstances and bargaining positions at the time the company is constituted. Once those arrangements are incorporated into the articles and registered with the Registrar of Companies, they bind all shareholders, including minorities, who may find the arrangements uncomfortable. Courts should not interfere with legitimate contractual governance arrangements simply because a minority shareholder finds them disadvantageous." On the NCLAT's reinstatement order, the court drew a sharp and fundamentally important line. The remedies available under Section 242 of the Companies Act, while broad, must be proportionate to the harm that has been established and must remain within the category of remedies appropriate to a company law tribunal. Ordering the reinstatement of a removed executive, directing a company to re-employ a specific individual in a specific management role goes beyond what a company law tribunal should do in an oppression case. Courts and tribunals are guardians of shareholder rights. They are not the managers of companies. The power to hire and fire the chief executive of a company belongs to the board of directors, not to the judiciary. The NCLAT had exceeded its jurisdiction. The reinstatement order was set aside. On the conversion to private company status, the court held that the conversion had followed the proper statutory procedure under the Companies Act and had been approved by the Registrar of Companies through the correct process. The NCLAT's finding of illegality was overturned. Cyrus Mistry did not return to Tata Sons. N. Chandrasekharan, who had been appointed executive chairman in the immediate aftermath of Mistry's removal and had led the group through the entire period of the litigation, continued in the role. The Shapurji Pallonji Group, in the years following the Supreme Court judgment, faced significant financial difficulties of its own, having accumulated substantial debt, in part through borrowing against the value of its Tata Sons stake. The SP Group explored various options for monetizing or restructuring that stake, a process complicated by the fact that Tata Sons was now a private company with transfer restrictions on its shares. The economic and legal dimensions of the Mistry family's position as a locked-in minority shareholder in a private company controlled by a majority with whom their relationship had been permanently altered by 5 years of litigation, these dimensions illustrated with uncommon clarity why the rules governing minority shareholders in private companies matter not merely as abstract legal principles but as questions of real financial consequence for real families and real institutions. And then, on September 4, 2022, Cyrus Mistry died in a road accident on the Mumbai-Ahmedabad National Highway in Maharashtra. His car struck a divider at high speed. He was 54 years old. he had fought for 5 years through every available legal mechanism to vindicate what he believed was a legitimate record of leadership of one of India's greatest institutions. He had won in the NCLAT, he had lost in the Supreme Court. He had not lived to see whatever the next chapter of his family's relationship with Tata Sons might have been. In the immediate aftermath of his death, members of the Tata Group leadership expressed personal condolences. Ratan Tata described his passing as a personal loss. The legal war was over. The human story ended on a highway. And the questions that the case had raised about how power is structured in India's great family institutions, about what minority shareholders can realistically expect when they find themselves in conflict with a 66% majority, about what courts can and cannot do when boardroom power is disputed, those questions did not end with him. They remain as open questions in Indian corporate life, waiting for the next case to test them. What does the Tata Mistry case teach every corporate leader, every investor, every director, and every shareholder in India? The first and most fundamental lesson is about the Articles of Association. The articles are not a formality. They are not boilerplate. They are the constitutional document of a company, the document that determines with legal force how power is distributed between shareholders, how directors are appointed and removed, what rights specific shareholders have beyond their pro rata economic interest, and what happens when disputes arise. The Tata Sons articles gave the Tata Trusts rights that significantly exceeded what their percentage shareholding alone would have provided. Those rights were upheld by the Supreme Court as legally valid. Every investor who places capital in any private company, however well known, however trusted, however prestigious, must read the articles before investing, because the articles describe the specific legal world in which their investment will exist. Failing to read them is not ignorance of the law in general. It is ignorance of the specific law that governs the specific company in which one's capital has been placed. That ignorance has consequences. The second lesson is about the nature of oppression under Section 241 of the Companies Act 2013. The standard is high deliberately because the alternative, a standard so low that any management disagreement could be characterized as oppression and brought before a tribunal, would make it impossible to govern any company with consistency or predictability. The right of the majority to manage, including the right to change management, is fundamental to the corporate form. The Supreme Court's judgment made this explicit and unambiguous. But the judgment also made clear that Section 241 is a real remedy, not merely a theoretical one. Conduct that is genuinely burdensome, harsh, and wrongful, conduct that strips a minority of their economic rights, excludes them from legitimate participation in the governance of the company, or uses the machinery of governance to harm rather than to manage, can and will be addressed by the tribunal system. The Tata Mistry case fell on the legitimate side of the line. But the line exists. Finding it in any specific case requires careful analysis of the specific facts, the specific articles, and the specific conduct in question. The third lesson is about corporate succession, perhaps the most important and most consistently mishandled challenge in Indian family business history. The Tata Group's decision in 2012 to appoint an outsider as chairman was ambitious and genuine. It reflected a real aspiration to separate the institution from the founding family in the way that the most mature corporate governance models require. The difficulty it encountered, the breakdown in the relationship between Mistry and the trust nominees, the accumulation of strategic disagreements, the abrupt removal, the legal war, illustrates how fragile that aspiration can be when the structural conditions for it do not yet fully exist. A new chairman cannot exercise genuine executive authority if the previous chairman remains actively present and influential. a professional management model cannot coexist with a governance structure designed around the interests and instincts of a founding family, unless the governance structure has been genuinely modified to reflect the new reality. Succession is not a single appointment, it is a sustained institutional transformation. And institutions that attempt that transformation without completing it, that is, install a new leader without genuinely transferring the authority that leadership requires, are setting the stage for exactly the kind of conflict this case produced. The Tata Group today is led by N. Chandrasekaran, who has pursued an ambitious strategic agenda, including the acquisition of Air India, significant investment in electric vehicles and semiconductor manufacturing, and the emergence of Tata as a major player in India's manufacturing renaissance. Bombay House stands as it always has, its heritage facade maintained alongside its modernized interior, a building that has witnessed more of India's industrial history than any other address in the country. The Tata name remains among the most trusted in India, perhaps the most trusted, built over 150 years on a combination of business ambition and ethical seriousness that has few parallels in the global corporate world. Whether the specific governance structures of Tata Sons today fully embody the principles that built that trust, whether the relationship between ownership and management, between the trusts and the executive team, between the company and its minority shareholders operates in the way that those principles require, is a question that the Cyrus Mistry case raised with unusual directness and that the legal system resolved without fully answering. The answer to that question will be provided, as it always is in the life of great institutions, not in courtrooms but in boardrooms, not in judgments but in decisions, not in the text of the Companies Act but in the character of the people who interpret it, apply it, and live under its authority every single day. The Companies Act 2013 was, at the time of its passage, hailed as a landmark modernization of Indian corporate law. It introduced the concept of independent directors with specific qualifications and responsibilities. It strengthened the audit committee framework. It introduced the corporate social responsibility mandate requiring large companies to allocate a portion of their profits to specified social purposes. It created the NCLT and NCLAT as specialized forums intended to resolve corporate disputes more efficiently than the ordinary civil courts had managed to do. And it strengthened the provisions on oppression and mismanagement, giving minority shareholders a more explicit and more accessible route to challenge the conduct of those who controlled the companies they had invested in. All of these were genuine improvements. The Tata Mistry case was the first great stress test of this new framework at the highest level of Indian corporate life. What the case ultimately revealed was that the framework was sound in its principles, but that the application of those principles to the most complex real-world situations involving immense financial stakes, competing legitimate interests, and deeply personal dimensions of power and legacy, required a level of judicial calibration that took 5 years and 3 levels of court to achieve. The Supreme Court's March 2021 judgment provided that calibration. It drew lines that had not previously been drawn with this clarity, and in doing so, it made the Companies Act 2013 a more mature and more workable instrument of corporate governance than it had been before the case began. There is one dimension of the Tata Mistry case that deserves attention beyond its immediate corporate law significance. The question of what the case revealed about the relationship between charitable institutional ownership and commercial enterprise governance. The Tata Trusts are not merely shareholders. They are registered public charitable foundations, institutions with a constitutional mandate to apply their resources for specified public benefit purposes, including education, health, arts, and scientific research. The institutions that the Tata Trusts have funded or supported over their history include the Indian Institute of Science in Bangalore, the Tata Memorial Cancer Hospital in Mumbai, the Tata Institute of Fundamental Research, and the National Centre for the Performing Arts. institutions that have had deep and lasting impacts on Indian scientific, medical, and cultural life. The funding for these activities flows ultimately from the commercial success of the Tata Group companies in which the trusts hold their 66% stake. This creates a governance structure in which a charitable foundation exercises decisive control over a collection of major commercial enterprises, and in which the commercial performance of those enterprises directly funds activities of enormous public benefit. It is a structure that has been celebrated, and rightly so, as a model of socially responsible capitalism. It is also a structure that creates governance complexities of a kind that pure commercial ownership does not. The Cyrus Mistry case brought those complexities into the open as they had never been before. The Supreme Court validated the structure as legal. Whether it is optimal, whether it creates the best possible conditions for both commercial excellence and charitable mission is a question that each generation of Tata Group leadership must honestly ask and honestly answer. The fourth and final lesson of the Tata Mistry case is perhaps the most personal and the most important for anyone who will ever find themselves in a position of significant corporate leadership. Power in a company, real power, the power to make decisions that matter, does not flow automatically from a title or an appointment. It flows from relationships, from trust, from the day-to-day working reality of being the person that other decision makers look to for direction. When Cyrus Mistry was appointed executive chairman of Tata Sons in 2012, he was given the title and the formal authority. What the subsequent 4 years demonstrated, in the disputes that accumulated, in the resistance he encountered, and the eventual removal, is that the formal authority and the real authority had not been successfully transferred. The previous chairman remained present. The trust nominees on the board retained strong views and strong influence. The institutional culture of the group remained oriented toward a specific vision of the future that was not always identical to Mistry's own. A new chairman operating in these conditions, however intelligent, however committed, however correct in his strategic assessments, is governing at a structural disadvantage that no individual brilliance can fully overcome. The lesson for every succession process in every institution is that appointing a new leader is the beginning of a transfer of authority, not its completion. The transfer is complete only when the person who held power before has genuinely stepped back, not merely stepped aside, and when the governance structures that supported the previous leadership have been adapted to support the new one. In the Tata Group in 2012, that transfer was not complete. The consequences of its incompleteness played out across 4 years and then 5 more years of litigation in ways that no one who was present at the appointment ceremony in 2012 could have anticipated or desired. Cyrus Pallonji Mistry died at 54. He was, by every account of those who worked with him and knew him personally, a man of genuine intelligence, deep seriousness, and strong ethical instincts, qualities that made the circumstances of his departure from Tata Sons and the years of litigation that followed all the more painful for the people who respected him. He had believed, when he accepted the chairmanship in 2012, that he was being given a real opportunity to lead one of India's greatest institutions through a period of genuine transformation. He had worked with that belief for 4 years, raising concerns that he considered important and honest and in the best interests of the companies he was charged with running. He had then fought for 5 years in the courts of India to establish that his concerns were legitimate and that the process by which he had been silenced was legally flawed. He won in the NCLAT. He lost in the Supreme Court. He did not live to see whatever resolution the SP Group's long-running economic situation with Tata Sons might eventually have produced. The road accident on September 4, 2022, closed his chapter of this story with an abruptness that the legal system, with all its careful procedures and extensive reasoning, had not. The questions he raised remain. The institution he tried to lead continues. The law that governed their conflict has been, because of that conflict, more clearly articulated than it had ever been before. And the boardroom at Bombay House, which has been the site of so much Indian corporate history, now carries in its walls the memory of this particular chapter, of the first outsider who sat in the chairman's seat, and of what it cost him, and of what the country learned when he was asked to leave. If this story moved you, if it made you think differently about what it means to govern a great institution and what the law can and cannot protect when power is in conflict, please share it with someone today. And if you know of a case that deserves to be told, write to us. Every boardroom has a story the public never fully hears. This is HeartLine Justice, where the law meets the human heart.